Welcome to Tompkins Talks. So, you know the drill by now. I give you a summary of a recent case in a short, snappy way that's easy to digest whether you're at home, as most of us are, in the office, or on the move. As this is a Tompkins Talks lockdown special, I'm doing it once again from home without the help and support of our fantastic business development team. So, it won't be as whizzy as usual, but I hope you still enjoy it. As an extra special bonus for you, I'm actually going to talk about two cases rather than the usual one. These cases are Travelodge and Prime Aesthetics, and the rather snappily titled Re a Company brackets injunction to restrain presentation of a petition close brackets. So without further ado, let's start with the backstory. One of the most potent weapons in a landlord's arsenal when its tenant of commercial premises does not pay the rent is to serve a statutory demand. If the tenant fails to pay the sum demanded within 21 days, a landlord can present a petition to the court to wind up the tenant company. As most tenants wish to avoid winding up petitions being presented or advertised, this means that the end result of a service of a statutory demand is often the payment of the debt. Now, when the COVID-19 crisis began, there were no restrictions on landlords serving statutory demands, and a number of them did so when their tenants failed to pay the March quarter rent, either in full or in part. However, on the 23rd of April, the government issued a press release in which they stated they intended to bring forth legislation to ban the use of statutory demands issued between the 1st of March and the 30th of June, and the presentation of winding up petitions from the 27th of April through to the 30th of June. It took some considerable time, but on the 20th of May, the draft Corporate Insolvency and Governance Bill was published. Whilst this contains provisions dealing with a number of matters, the relevant bits in relation to statutory demands and winding up petitions are that on or after the 27th of April, no winding up petitions can be presented until a month after the bill becomes law, unless the creditor can demonstrate that COVID-19 has not had a financial effect on the debtor company, or the debtor would have been unable to pay its debts irrespective of COVID-19. The bill is still not law, but it's anticipated coming into force towards the end of June. So, with the bill not being law yet, what's the position in relation to statutory demands served and winding up petitions presented where a tenant has failed to pay the March quarter rent? This has been tested in the Travelodge and a company cases. In the Travelodge case, the hotel chain sought an injunction to prevent a winding up petition being presented at a time when the government had issued its press release, but the draft bill had not been published. One of Travelodge's arguments was that the landlord should not be allowed to present the winding up petition, as it was bound to fail due to imminent legislation. In the A Company case, the unnamed retailer sought an injunction to restrain the presentation of a winding up petition at a point where the draft Corporate Insolvency and Governance Bill had been issued, but it was not law. One of the retailer's arguments was that the likelihood of the bill would become law. So, what was the outcome? Well, in both cases, the court was satisfied that even though the changes announced by the government were not law, they could take account of what the law would likely become. In view of these prospective changes, which Mr. Justice Morgan in the A Company case said he had a high degree of confidence would become law, injunctions were granted in both cases, restraining the landlords from presenting winding up petitions. So what does this mean? Well, it's pretty rare for a court to make decisions on the basis of what is likely to happen to the law rather than what it actually is. Leaving that aside, it appears that any landlords looking to present winding up petitions prior to the bill becoming law will be unlikely to be able to do so. In the meantime, we wait for the legislation to be passed, which I understand is likely to happen around the 23rd of June. If you found this useful, please comment, like or share the video. I'll see you soon for another Tompkins Talks, and I hope you and yours stay safe and well.